Good afternoon to you all, or good morning, or good evening, wherever you are. I'm Nick Austin, a partner in the shipping team at Reed Smith in London, and wearing another hat, also a member of the Council of the London Shipping Law Centre. And on behalf of Dr. Leigh Shepherd, the chairman of the LSLC, and on behalf of Reed Smith, it gives me huge pleasure to welcome you all to this 10th webinar in the Centre's global webinar series, a series initiated by the LSLC in May this year, following what will no doubt be we hope, a temporary cessation of the usual live in-person seminar programme. When we suggested the topic of sanctions to the LSLC over a year ago now, the world was in many ways a very different place. Although sanctions affecting trade and shipping were ever present then, the world has since seen and will continue to see a significant geopolitical and economic change, all of which will no doubt have an impact on the sanctions landscape in the months and years to come. So the LSLC is delighted with Reed Smith to be discussing this important topic today. We have a truly stellar panel today, but none more so than our chairman, Sir Nigel Teare, who will shortly introduce our panel members, Mike Salthouse and my Reed Smith colleagues, Leigh, Hansson and Alex Brandt. Sir Nigel really needs no introduction at all at any LSLC event, but he's going to get one anyway. Sir Nigel Teare sat as a judge of the Queen's Bench Division from 2006 until his retirement from the High Court bench on the 30th of September this year. He now accepts appointments as an arbitrator. Sir Nigel has, as you will all know, had an exceptional career, first as counsel, of course, and then as a High Court judge. In 2011, he was nominated the Admiralty Judge, later being appointed judge in charge of the Commercial Court from October 2017 until his recent retirement. He has, of course, decided many of the most high-profile cases of recent years across many different business sectors, but obviously for today, including, of course, shipping and the maritime world. With that introduction and my welcome out of the way, Sir Nigel, I'll hand over to you.
Thank you very much, Nick. It is indeed a great pleasure to chair this discussion of a subject which is of immense practical and legal significance to the maritime community. Sanctions are the method by which governments seek to give effect to their foreign policy. The ultimate object of sanctions is the state against whom they are directed. But in order to be effective, they must inevitably affect not only those who trade with entities in the state, but also those whose activities may in some way, directly or indirectly, support the activities of such entities. So the effect of sanctions can be and is wide-ranging. Shipping, for obvious reasons, is particularly exposed to the reach of sanctions, and so I hope that this roundtable discussion will be of interest to many of you. When sanctions issues reach the Commercial Court, they tend to do so in the context of a dispute between two contracting parties whose dealings with each other are impeded or indeed stopped by the perceived reach or effect of sanctions. The court is required to resolve the dispute by applying the terms of the parties' contract, but in order to do so, the court has to have an understanding of the sanctions, and that may involve forming a view as to the effect in law of the sanctions themselves. That was the case in a matter which came before me in the Commercial Court, where the underwriters of a marine policy resisted payment of the claim on the grounds that payment would expose them to sanctions. The case concerned the US sanctions against Iran, which had been introduced by the Obama administration, then lifted by that administration before being reintroduced by the Trump administration. It also involved the EU blocking regulation, which sought to prevent persons from complying with the sanctions regime, which had been reintroduced by the Trump administration, a regulation that makes an already complicated area yet more complicated. These cases can, of course, require speedy decisions, and that can be difficult when the court is being asked to rule definitively on a particular issue. But these cases are, I suspect, only the tip of the iceberg. On a practical level, those who deal in any way with business interests connected with states against whom sanctions have been introduced must deal with them regularly and develop the way in which they do business to avoid or at least minimize the risk of conflict with the sanctions regime. Doing so can be very difficult because some entities seek to hide their sanctions breaking practices, leaving innocent parties who deal with them exposed. To this end, the UK authorities and the US authorities in May and July of this year have issued advice to shipping companies and insurers as to the appropriate good practice which should be followed to assist in detecting sanctions violations. The maritime industry is expected to demonstrate due diligence, not only in being familiar with the sanctions in force, but also in how to spot possible breaches so that they are not caught unawares. It is on such issues that my colleagues today are well positioned to speak. They have a close and up-to-date involvement with the legal and practical problems which face the maritime community in these challenging times. Leigh Hansson is a partner in the Global Regulatory Enforcement Group at Reed Smith. She advises multinational corporations involved not only in shipping, but in other sectors as well. She advises on export administration regulations, international traffic in arms regulations, and OFAC, the Office of Foreign Assets Control. And she represents clients before the tribunals which deal with the enforcement of sanctions. Alex Brandt is the lead member of the sanctions practice in the Transportation Industry Group at Reed Smith. He advises the maritime community on sanctions matters, not only with regard to the investigation by and disclosure to the relevant tribunals, but also with the due diligence required of owners, charterers, and traders. And Mike Salthouse is the Global Director of Claims at the North of England P&I Club, and he is Chairman of the Sanctions Committee of the International Group of P&I Clubs. He has led the industry's engagement with the UK, the US, and the EU authorities on the topic of sanctions since 2011. So I think you'll agree a wealth of relevant and valuable experience is on hand today. May I first ask each of them what they perceive to be currently the sanctions hotspots for the maritime community.
Hi, Sir Nigel. Thank you very much. I'll kick that one off. I think a good question is really what hasn't been a sanctions hotspot for the maritime community. But from my perspective, let me just briefly talk about Venezuela. And to get us all on the same page, I think many of you will recall back in January of 2019, OFAC designated PDVSA as a specially designated national, an SDN. And what this means, very briefly, is that US persons are prohibited from engaging in virtually all transactions with PDVSA. Non-US persons are exposed to risk of sanctions if they provide material support or assistance to PDVSA, or if they operate in the oil sector of the Venezuelan economy. Shortly thereafter, about a month later, in August of 2019, President Trump blocked all of the property of the government of Venezuela. And so essentially that put all US persons at a risk of sanctions for engaging in basically any transaction involving the government of Venezuela. For non-US persons, again, they're exposed to risk of sanctions if they provide this material support or assistance to any government of Venezuela entity that's specifically named on the SDN list. And then obviously causes problems with US dollar transactions, which we all know, is the currency of choice for the maritime community. In 2020, I mean, obviously we saw a number of robust sanctions actions, particularly over the summer involving Venezuela. First, in February, we saw OFAC designating Rosneft Trading for operating in the oil sector of the Venezuelan economy. About a month later, when OFAC moved its trading operations to TNK Trading, OFAC went ahead and designated TNK. I think shortly thereafter, Rosneft wisely announced that it was going to withdraw from the Venezuelan market. In June, we saw OFAC designate 4 owners and 2 vessels for operating in the oil sector of the Venezuelan economy. Most of those had only engaged in one Venezuela-related voyage, so it wasn't, sustained, consistent amounts of traffic in the area was enough to get them designated. And then again in June, we saw OFAC designate 2 more owners and 2 more vessels who were involved in a transportation of oil allegedly stolen from the people of Venezuela pursuant to an oil for food scheme that wasn't exactly what it appeared to be on its face. At the same time though, OFAC delisted 2 vessels and 2 companies that were originally sanctioned back in June for agreeing to revamp their compliance programs and also to cease their involvement in the Venezuelan economy. As long as the Maduro regime was in power. And I think that really goes to show just how quickly I think the government is willing to make changes, both positive and negative, when it comes to listing and delisting. August 2020, that was a big shift. We saw a seizure order issued by the Department of Justice for 4 oil cargoes of around 1.1 million barrels of crude heading from Iran to Venezuela. And I think we can certainly expect to see more of these types of actions in the coming months. Certainly, issues surrounding Venezuela are not going to be going away. Alex, do you want to talk a little bit about what you're seeing with regard to Iran right now?
Yes, Alex.
Yeah, thank you both, and thank you everyone for joining us today. It will come as no surprise to our viewers, I think, that Iran has and continues to be a real hotspot for the maritime community. Very succinctly, the Obama-era administration played an important part of entering into the nuclear deal with the EU3 and the United Nations. The Trump administration walked out of that deal and sought to reimpose comprehensive sanctions against Iran, marking a sort of a marked fork in the roads between the EU position and the US position. That in turn has led to quite complicated anti-boycott legislation, which Sir Nigel spoke about earlier. For those in the industry, and not least because Iran has significant oil reserves, we've been kept extremely busy, and that has not just been in terms of owners and charterers of crude oil, but it's also been sale and purchase of vessels, and also the targeting of ancillary service providers. For example, we saw last year, back in September, I think it was, Leigh, OFAC giving specific guidance on those who provide bunkers to Iranian vessels. And certainly what we've seen is engagement by the US authorities with those in the broking trade, with port state control, bunker suppliers, as well as the classic punch-ups between owners and charterers in respect of not just crude oil, but other commodities. In May of this year, we saw the US take steps to designate, among others, the National Iranian Tanker Company and NIOC, the Iranian oil company, under terrorist legislation, linking them with the Iranian Revolutionary Guard Quds Force. I think at the time we thought that was primarily symbolic. But as Leigh said, with these seizure orders that we're seeing coming out of the US, it's quite clear that actually the implications of linking these Iranian organizations to terror gives the US additional powers to seize cargo, and that's something we've seen and will continue to see. Finally, on Iran, and I think we'll also see this in respect of Venezuela, we've seen increasingly convoluted attempts by the Iranian government, or manifestation of the Iranian government, to ship particularly crude oil out of Iran. And that has led to owners being, owners and other operators in the industry being duped and finding out that they have a hand in sanctionable activity in real time. And that, of course, is in many ways, it makes their life more complicated, and the task of their advisors in how to grapple with that situation that unfolds. So that's a little bit of scene setting in respect of Iran.
Thank you, Alex. Mike, can you contribute on this question as to where the hotspots are?
Yes, thank you, Sir Nigel, and good afternoon, everybody. A few words about Nord Stream. About 6 months ago, I was sitting there saying, well, what's all the fuss about Nord Stream? Nord Stream, as many of you will know, is a system of offshore natural gas pipelines. They're running from Russia to Germany. They're operated, managed, or invested in by Gazprom, although I think Nord Stream itself is a Swiss company. I think Nord Stream 1 was completed in about 2012. Nord Stream 2 is still underway, but the fabrication of the pipeline has been impacted significantly by US sanctions. The US doesn't like Nord Stream and these sorts of projects because, in their view, they unacceptably compromise Western energy security. And in fact, US antipathy towards Russian energy pipelines is nothing new. Those of you with long memories may remember in 1981 that the US implemented sanctions that prevented US companies from exporting oil and gas technologies necessary for the Trans-Siberian pipeline. And in 1982, they extended those sanctions to cover the subsidiaries of US companies that were working in Europe on those projects. What was interesting then, and I mentioned this by way of anecdote, was the response to that from the UK government in particular, which reacted very aggressively to the imposition of an early form of US secondary sanctions at that stage by enacting what was called the Protection of Trading Interests Act, which required companies doing business in Britain to notify the UK government of any requirements that were being placed on them by the US government, and it was then up to the UK government to determine whether or not it would impose restrictions on such companies, compelling them to comply with UK law and ignore US law. So that was way back in 1981, at a time when the Reagan and the Thatcher governments were actually quite well aligned on the West. So fast forward to 2020, and we have now Nord Stream 2, Nord Stream 1 having already been completed. And I think what's happened there is that industry generally, and P&I clubs specifically, have been subjected to very significant US outreach over the last 6 months, which highlight the risks that exist from existing and anticipated US legislation, particularly countering America's adversaries through Sanctions Act, or CATSA, and the Protecting Europe's Energy Security Act, or PISA. Now, until quite recently, the State Department had adopted a policy under CATSA not to target these pipelines where the project contracts have been signed before August 2017. And this essentially eliminated Nord Stream 2 and a similar project, Turkstream, from the scope of CATSA. But in July this year, the State Department announced a change to this policy, clarifying that the focus of CATSA now would be on the wider scope of Russian energy exports, and the change in policy would now include both Turkstream and Nord Stream 2, so any ongoing activity irrespective of when the contract was signed. And the effect of that was that if you operated any sort of vessel in connection with the Nord Stream 2 or Turkstream project, providing services to vessels, management, insurance, that's us, port service, etc., then as a non-US person, you would be exposed to sanctions. There are monetary thresholds to be met, But in the case of insurers, for example, it's not clear whether that relates to the amount of cover we provide. And in the case of P&I clubs, obviously that's quite a lot, would easily exceed the monetary threshold, or a more restrictive interpretation, which may just relate to premium. So question marks over the level of exposure to which we're all exposed to, and obviously risk appetite within insurers in relation to US sanctions in particular, and UK sanctions is very, very low. In December, so this time last year, the US, going to PISA now, had enacted a piece of legislation called PISA, which came into effect back in December 2019. Essentially, this has been a fairly ineffective piece of legislation. And there are a number of senators and the like who are simply not happy with the lack of sanctions that have been issued under PISA and the continuation of the Nord Stream pipeline's construction. So there are amendments now being proposed to PISA. There are two bills, I understand. I'm not familiar entirely with the US legislative process, but we have a Senate bill and a House bill, both seeking to clarify PISA through what will be called the PISA Clarification Act. And this has really got us quite worried. The reason why we're all quite worried about this is that in addition to the targeting of the pipe-laying vessels, which, so you might be a ship owner operating one of these vessels, or like us, an insurer, or perhaps a bank providing finance to them, PISA's looking to include within the scope of its remit anything that's involved in pipe-laying activities, and that would include things such as site preparation, trenching, surveying, placing rock, stringing, but also the sort of thing such as insurance and financing. And what is really worrying us is that there, up till very, very recently, it didn't look as though there was going to be any discretion on the part of the executive when it came to applying sanctions. So in other words, if it was found that the north of England, in our case, was providing insurance unwittingly to a vessel engaged in pipelaying, then there would be a legislative requirement on the executive to impose sanctions on the north of England, which would be potentially catastrophic for ourselves and indeed any other group company that was involved with that. So there was no due diligence exception for underwriters, insurers and reinsurers. Now,
thank you, Mike. Can I ask you, in the light of those well-known areas of sanctions which have a particular effect on the maritime community, how has the maritime community been able to respond to these sanctions?
Yeah, just to kick this off, and something that you had alluded to earlier, Sir Nigel, I think most of you are aware that both the United States and the UK have issued guidance specifically to the maritime community, highlighting ways in which duplicitous shipping practices can be detected and avoided. Speaking just on the OFAC side, this isn't the first advisory that the US government put out geared towards the maritime community. There was guidance back in February of 2018 and 2019 regarding North Korea, 2019 for Iran, and then also Syria back in November of 2018 and 2019. But this advisory in May of 2020 was really the first comprehensive piece of guidance that OFAC has put out, the US government's put out, both in terms of its scope as well as its detail than any other advice that's been out there. Because it's not limited to advice on specific sanctions regimes, but it's really meant to be this comprehensive sanctions compliance guidance to the maritime community in general. And I know just from the private practice side, when that guidance came out, it really I think sent a lot of us running around like crazy, trying to make sure that we were all up to speed with a number of the practices that OFAC was expecting from us. Some of these things that were identified that my compatriots on the panel are going to be talking about, things like risks with STS transfers, AIS manipulation, which is obviously a huge issue within industry, training, compliance policies and procedures. But there's tons of those things that OFAC has really come to the forefront and has expected those in the industry to really develop.
Thank you very much, Leigh. Mike, can you contribute on this as to how the maritime community has responded?
Yeah, I mean, well, speaking for the P&I clubs, we've issued an awful lot of circulars, and we do that for two reasons. First of all, to inform our members about the areas of risk, and also the guidance that is offered by the US and UK governments, and that means four circulars during the course of this particular year, and then the clubs individually will also seek to publicise these things through industry updates and so on. I think we've all had to adapt our practices. We've all had to read and take note. But the other thing I think that the industry has done, or the P&I clubs in particular, is we've worked very hard to engage with particularly the US authorities, because whatever we think about the United States and the means by which it enforces sanctions, it does present an existential risk to the majority of businesses. None of us as insurers or ship owners can really afford the cost of designation, particularly if designation is not lifted relatively quickly. So one of the things, whilst there's an awful lot we've done in the public domain in relation to highlighting the risks to ship owners, privately there has been enormous amount of engagement going on behind the scenes, explaining really some of the difficulties associated around some of the practices that the US and subsequently the UK governments have been advocating. So.
Thank you, Mike. Alex?
Yeah, I think obviously what Reed Smith sees, so we work both with P&I clubs, and including North, of course, but also with ship owners. And for them in particular, there comes a huge administrative, or potentially huge administrative burden that comes with the requirements of the OFAC guidance, and the UK guidance follows shortly, it followed hot on the heels and adopted many of the same points. These guidances require practical steps, such as looking at their counterparts, checking their counterparts' history of activities, looking at what ships have been up to. They've been looking at and requiring, screenings as well. And if you're not a large ship owner, then this can prove very challenging. And so what we've seen and what we've been helping our clients with is developing effective compliance policies, which corresponds to the level of risk and exposure that they might be facing.
Thank you. Thank you. When a sanctions issue does arise or develop, and it is appreciated by a ship owner or a charterer, how does he go about handling that issue? Can any of you respond on that?
Well, I'll have a first stab at that. So Nigel, I think it's very difficult. I mean, part of the success, I think, of the industry in implementing these sanctions compliance guidances is that we have all become much better able to detect sanctions violations. It used to be the case, or at least, this is historically what we saw, is that you had a violation that took place 9-12 months ago. The State Department or OFAC, normally the US taking the lead on these things, found out about it, didn't tell anyone, or did tell someone, but put you on the blacklist, and then you were left scrabbling around trying to work out how best to try and salvage your business. So that's how it was. But now we have we've become far better at seeing these duplicitous shipping practices, which means that the whole thing becomes much more three-dimensional, because you may find a scenario where, if you're a ship owner, you're halfway through loading a cargo on board your vessel, and then you get a knock on the door from Mike, possibly, more and more commonly now, and saying, hang about, the club is keeping an eye on these things generally, and it's got important intelligence that that you can't disregard. So maybe just when you're the unfortunate soul in that situation, I would say that some of the things that might be worth thinking about is, first of all, what protection do you have in your contracts? Now, it's of course it's one thing complying with the regulator, and obviously that's something that engagement with the regulator is something Leigh will talk about, but something that we would obviously recommend and endorse. The consequences of designation are just too severe to ignore. But you also want to be balancing that against your contractual protections. You know, in the summer seizures, for example, where the US sought to confiscate oil, that of course exposes you as the bailee of cargo, for example, to potentially astronomical misdelivery claims. And unless you've got the contractual protection there, or the assistance of whatever court is competent to deal with that, then you may find yourself stuck between two almost equally bad evils. You know, if you have no defense to, you know, tens, hundreds of millions of misdelivery claims. So that's one thing I think you should be thinking of. And tied to that is going to the court or tribunal under your contracts and looking to see what remedies can be afforded a party on an interim basis, or at least on an urgent basis. And I suspect, Sir Nigel, that you have and will continue to see those types of orders, or at least requests for those type of orders coming your way.
Yes, it's a difficult one, that. I think you've mentioned that parties would be well advised to have terms in their contract which seek to provide for the event of sanctions. The assistance that the court can give would, on an urgent basis, would very much depend upon the nature of the remedy which is sought. If a party comes to the court seeking interim relief in the form of an injunction, for example, restraining a charterer from giving a particular order, the court would be able to respond, applying conventional principles. Is there a serious issue to be tried, that the owner has a right that such orders should not be given? And if so, where does the balance of convenience lie? But if, of course, the parties come before the court wanting a definitive ruling on the matter, it's more difficult to give that without delay, because a final decision is sought. And in those circumstances, arrangements would have to be made for a very speedy trial indeed. That is, of course, possible, but speedy does not mean immediate. But certainly, it seems to me that the court would be able, depending on the remedy, to respond. Where arbitrators have jurisdiction, there may be a little more flexibility there in the way in which they can respond, because they are not as hidebound by procedural rules as perhaps the court is. And so it may well be that arbitrators are able to respond with definitive rulings in a manner which might be tricky for the court. Mike, can you contribute to this?
I mean, look, it is a very difficult position, and I do very much recognise the example that was given by Alex of the ship owner who's halfway through an STS suddenly receiving information that the cargo that they thought was from Iraq is actually from Iran, and that creates all sorts of problems. It creates a problem in the sense that people like us, banks, flag, class, as this information starts to leak out, will seek to distance themselves from the vessel and the vessel owner, because they have no alternative but to do so. It is unlawful as a matter of US law for us to provide insurance to a vessel which is carrying Iranian oil. There is a risk of sanctions even under English law if, as is commonly the case, most of those cargoes have the involvement of the Iranian Republican Guard Corps, which is a designated entity in the UK as well as the US, and therefore that will trigger the sanctions exclusions clauses. Banks, and I see somebody is questioning the role of banks here, take a very risk-averse approach to anything, and they simply will not engage, and it is very much up to them to, whether or not they engage in anything that carries with it any risk of sanctions or any possible activity that might be sanctions breaking. So the ship owner is really left in a very difficult position. And from our point of view as clubs, what I think we all try and do is to help our members, but we have to terminate the cover. I mean, it is black and white. If there is a risk of the activity putting us in breach of sanctions, then the cover will cease. What we can do is we can provide the support to the owner in terms of looking at the matter ourselves, which we have to do because we have compliance policies. We have to investigate it, and providing some of the outcomes of that compliance work to an owner to help them form their own investigations. And as I alluded to earlier, the international group clubs have very developed relations with the UK, US, and also the EU authorities, and we can engage with those. We can seek clarification as to what the concern is, and we can try and find out how best to assure the authorities that this owner has been inadvertently caught up in what is very often a very sophisticated state-sponsored smuggling operation. It beyond the capacity of somebody exercising industry standard due diligence to identify the source of the oil on many occasions.
Thank you, Mike. Leigh, are you do you wish to say anything on this topic?
Yeah, I mean, just a couple of points. Not only the practical things that Mike and Alex have also noted, but you also have to think about, what a PR and communications nightmare these sanctions matters have become. Sanctions busting is increasingly becoming covered by major news sources. We often see it on the front page of international papers across the world. And this can be a real PR nightmare for any organization. Even if you've done absolutely nothing wrong and you're inadvertently caught up in one of these schemes, a lot of companies, particularly your top tier organizations, are doing negative news searches these days, and they may reject you as a potential business partner, not necessarily for any legal reasons, but for these reputational reasons. So you need to make sure, as part of your, compliance team, you've got the PR and the communications management side of things covered. And then one thing that we haven't really touched upon is this whole issue of, self-reporting to the regulatory bodies. I know a lot of people have a lot of different views on it, both, pro-disclosure, both, and anti-disclosure. And there's certainly going to be, risks as well as potential benefits when you raise a potential issue with the regulators, and particularly on, the US side. And, ultimately it's a business decision, but every case is different and it has to be looked at very carefully. Do you want to put yourself on the regulator's radar? And, fingers crossed and issues never discovered. Certainly, with more sophisticated tracking programs, I think the days of things remaining undiscovered are long gone. But you have to keep in mind that you can get, I think, a lot of good advice and guidance from the regulators. I think there is, certainly, some organizations have been burned. They're fearful, but if handled the right way, I think engaging with the regulators can be very helpful and can assist getting you out of difficult situations.
Thank you. One of our attendees has asked about whether anybody can assist on the question of banks when they impose a prohibition on payments involving certain countries and the problems which that can cause. Do any of you have experience on that topic?
I mean, I can. Mike, do you want to start, and I can jump in after you?
I suspect we all do, but I think the problem here is that marine business is a very, very small part of a bank's portfolio, and the scale of the fines meted out, particularly by the US two banks, you know, BNP Paribas was what, $9 billion, Standard Chartered 2.45 billion from memory, are so significant that the banks are very risk averse, and they because of the nature of their relationship with their customers, they can very much choose whether or not they're prepared to engage in a particular piece of business. So there's actually very little you can do to persuade a bank to remit a payment that it's uncomfortable with. No matter how big a ship owner you are, no matter how big an insurer you are, you really don't have that level of commercial clout. We have, as an industry in the past, managed to get some form of assurances from particularly the US, because we're not US entities, we can't really get a license which would apply to us, which has enabled some of these payments or provides sufficient comfort for some of these payments to go through. But it really comes down to the individual bank appetite. If it's not prepared to do it, it won't do it, and that's certainly been our experience. Leigh.
Yeah, I mean, absolutely. It really is up to the bank's risk appetite, and you know, quite frankly, whether they've been burned in the past or not. Certainly, though, if you're if you're engaged in something like humanitarian trade, dealing with food or medicine, I will say it is slightly easier to get some traction dealing with the bank, but it is certainly by no means an easy task dealing, particularly with certain countries like Iran, for example. There's almost zero appetite for processing payments, even for things with licenses or operating under a general license. It can be very, very challenging, and the banks just are not in a place to engage.
Thank you. One case I was involved in the course of it, there were dealings with OFAC, the American office dealing with sanctions, and it was suggested that I, as the judge in the case, should write a letter to OFAC requiring that permission be given for a payment to be made. I think that was a case where parties wanted to make a payment into court, and the court was having difficulties in finding a bank that would allow the payment to be made into court. In the end, I decided that it really wasn't a matter for me to write to OFAC, and I think the parties did. But how easy is it, Leigh, to engage with the US authorities on these sort of matters?
So I think I have to say, and it's not a great answer, but it depends. I think if you're dealing with something that is an emergency, if it's something that's going to deal with potential loss of life or a potential, environmental disaster, or potentially involving Iranian crude, I think you will find that you'll get very, very rapid and very thorough response. They're incredibly helpful. I think, and particularly with COVID, though, I think general routine inquiries are a little bit slower to respond, and it's a little tougher to get engagement. License applications are fairly slow, and getting called back can be challenging. But certainly, if there's something very pressing, I think you will find that it's very easy to get engagement. I don't, Mike, if you've probably had similar dealings with the U.S. government on that.
Yes, I'd echo your view there. They are for thank God it's the United States, because their government officers are very open to engagement, and it's certainly possible to make representations. I do find it can be quite slow and quite a frustrating process, and we're left with the basic problem that the principal mechanism for allowing a non-US, well, there isn't a mechanism for allowing a new non-US party to carry out something which is ostensibly in breach of US secondary sanctions. We are reliant on the fact that US lawyers like yourself will advise us that it's inconceivable that the US would designate an entity where a license would apply to, would designate a non-US entity where the license would allow a US entity to perform that activity. Now, that's okay. Probably, I think most clubs would be more or less comfortable with that, because we do exist to support our members. We do exist to pay claims. That's not good enough really for banks, where there is a very, very little risk appetite, as the previous question alluded to. And, you know, why would they run the risk? They don't actually have any sort of hard and fast mechanism to sort of guarantee the fact that they won't run into a breach of sanctions. So yes, the US are open to talk about these problems, but the mechanisms for permitting particularly non-US parties to act are not there. Actually, that's the basic problem we find.
Thank you, Mike. So we're now almost at the end of 2020. Can I ask you all to look ahead to 2021? Is the world of sanctions going to get busier and more complicated in 2021? Alex.
Thank you, Sir Nigel. And I've seen on the Q&A as well that people are asking on the UK sanctions regime after Brexit, which is something that, you know, it's something that's very much on my and our team's radar. The specific question that's come in, I see, is whether this wonderful piece of blocking legislation is going to remain in place. You know, and that's a great question, not least because, you know, the nuclear deal continues, as far as I can see at least, to disintegrate around us. And we wait and see what the Biden administration is going to do, and Leigh will talk to that. To answer that direct question, my understanding is that recent government guidance has suggested expressly that the blocking statute will remain in place after Brexit, so come 1st of January. So I'm afraid that people stuck between that particular rock and hard place will be no better off there. Actually, the Foreign Secretary, in terms of the UK position after Brexit, the Foreign Secretary helpfully clarified the UK's approach to it a couple of days ago. I think it was on the 9th. The cut and thrust of it, as far as I can see, is that the UK is not bound, obviously, by what our friends on the continent are doing. But I think in the short term, we will remain fairly closely aligned. I think that there will be, particularly in the human rights sphere, I think that the UK will and very targeted sanctions against individuals and entities. I think that the UK will feel confident to go its own way, and indeed we've seen that a bit through this year. So I do think that, you know, it's always the way, you know, as we go deeper into next year, we're going to see more and more divergences. I don't think the UK will adopt a purely US approach. I think we'll tread a middle ground, and unfortunately, that it will be the task of ourselves and Mike and the industry to try and assist the maritime community in making sure their compliance policies are flexible enough to try and navigate, you know, not one, not two, but three, possibly more. So I think it is going to. I think 2021 is going to be very busy. That's my crystal ball, Katie.
Mike, what about from your perspective?
I'm a real pessimist. It's not going to get any better, I'm afraid. I don't see, like Alex, I don't see Iran sanctions relaxing in the short to medium term. I think even if the Biden administration felt free to act in an unconstrained manner as regards Iran, and I don't think it will find itself in that position, Leigh's probably better able to comment on that. You know, the US will want assurances from Iran before re-engaging in the JCPOA. There's been a lot of activity, and Iran, from a Western perspective, hasn't perhaps behaved itself particularly well. I mean, we have a state of war essentially between Israel and Iran at the moment, and that's likely to bubble over at any time. The amount of military activity that's going on between those two nations is quite frightening, but unreported. I think there's been some encouraging developments in relation to PISA in Nord Stream, most recently only a couple of days ago, where it is suggested that this sort of automatic imposition of sanctions, where we're found to be insuring a pipelaying vessel, will now not take place without consultation of certain governments, the UK government included. And I think also Biden is proposed will have some level of discretion there. Assuming Mr. Trump exits the White House and Mr. Biden moves in, so that's encouraging. But I think that the final comment really, sanctions is geopolitical, and the reality is European Western confidence in the US and its world leadership has been profoundly damaged, and we're at less than 4 years away from another election. And President Trump polled, I think, the second highest. Leigh will correct me here, but the second highest number of votes of any US presidential candidate. So in 3 and a bit years time, we could be back to where we were over the summer. And I think European governments will take a long time to rebuild the confidence and the collaboration that is so necessary in effective sanctions enforcement. And the last observation is that the big problem for industries like ourselves, is differing sanctions regimes, and we now have 3, whereas before we had 2. And whilst the UK and the EU will remain aligned in the short term, I'm sure there'll be divergence in the medium long term, and that will create big problems for industry and shipping more generally.
Thank you, Mike. And Leigh, how do you see the future?
Yeah, I mean, I'm hoping the days of where I'm having to pretend to be Canadian are gone, but I think at least for the foreseeable future, I think there's still going to be a little bit of a challenge between the U.S. and its traditional allies. I mean, I get it. I know there were probably quite a few celebrations around the world following the U.S. election results, but I agree with Mike, and unfortunately, I don't think anyone should get too terribly excited about expecting some sort of dramatic sea change, in sanctions designations or enforcement actions with the incoming administration. U.S. presidents, including Obama, have enthusiastically used sanctions, and I don't think we should expect to see the Biden administration to act much differently in this respect. I do think that there is going to certainly be more of an attempt for engagement with U.S. allies, greater use of diplomacy than in the past 5 years, much less of this, hammer approach. We're the United States, we do what we want. But I think, in the hot button areas that we've discussed, with regard to, places like Iran and Venezuela, I think, as Mike was alluding to, this new administration has many challenges ahead of it. It's going to be very difficult to roll back, a number of these sanctions programs, even if, the administration wanted to. But I think it's certainly going to be, interesting and fun for us sort of sanctions geeks for the next couple of months anyway.
One of the questions which has been asked concerns the UK's attitude to Russian sanctions with regard to the energy sector. And the question is whether these apply not only to products coming from Russia, but to imports into Russia. Does anybody have experience of that?
Well, the short answer, I think, is it depends a bit. Certainly the UK and EU, and actually the US as well, has got a bit more of a nuanced approach to sanctions than, say, the US in respect of Venezuela. You have sectoral sanctions, which look at specific types of transaction and look at specific types of activity. In addition to that, you have designations on individual companies and individuals. So I think it very much depends on who exactly you're dealing with and what exactly you're intending to do. So I think I appreciate that's a broad answer, but I think it's something that if you're looking at that sector, then it's worth a deeper dive. And obviously you have to do your due diligence, you have to do your screenings, you have to understand what exactly the constraints are, because it may not be the same depending who your counterparts are.
Yeah, thank you. When a charterer or a vessel is designated by the US government, what are the practical consequences of that, and what can be done about it?
I can tackle that just from a US perspective. When a vessel is we'll start with vessel, or an entity is placed on the US specially designated nationals list, depending on what the sanctions are. And this is, I think, one of the complicating factors with due diligence and the sanctions in general, is that you can't just, pop a name into the OFAC screening and say, do I have to worry about this or not? You have to understand what the underlying sanctions program is, and whether you're a US person, whether you're a non-US person, and you have to understand what the transaction is. Some SDNs are subject to secondary sanctions, meaning that non-US persons can themselves be designated if they engage in a significant or material transaction with that vessel or entity. Others only apply to US persons, and so you really only are worried about it if you're a US person or if you're dealing in US dollar transactions. But once you are designated, and let's assume it's a non-US entity and subject to secondary sanctions, I think what you could expect to see is inability to engage in any banking transactions. You're going to find both US and non-US companies, particularly large multinationals, will be unable to do business with you. It can be really a death sentence for a lot of companies that are unable to weather the storm and unable to get themselves off the list. There is a process to get removed from the SDN list. It appears fairly straightforward on its face. You apply to OFAC and send a letter and explain why you shouldn't be on the list. But there is a lot behind that process. And a lot depends on, what have you been alleged to have done? Have you corrected, the alleged violations, or is this just a complete, case of mistaken identity, which does happen, in fact, but nonetheless can have very devastating consequences. But it can be a somewhat complicated process, despite looking fairly innocuous on its face.
Leigh, I was just wondering if I could add to that. We've seen very different responses, or very different response times, I should say, in circumstances where a company has been designated. And I think one thing I would stress is that the lawyers or the club, we don't exist in a vacuum. And I think a key part of it is trying to pull together a team that's able to petition from a from a policy perspective. You've got the lawyers who are obviously doing their bit to try and make the legal representations, and then you have diplomatic channels as well. And certainly in the high profile shipping designations that we've seen in the last 12 to 18 months, it's been the effectiveness of a team together to help to sort the problem out. I'm not sure, Mike, I'm sure you've had experience of that.
Yes, I think what's interesting with this is that the US is learning, and I like to think they're learning because they've listened to what the clubs and others have said to them. But last year, 2019, we saw PB tankers put out of business by a very clumsy designation, and I don't think anybody would disagree with that. I'm sure some of the people here today were actually involved with that, and that involved the designation of the vessels and the management company, and then quite a slow process as Leigh was referring to, by which the designation was subsequently lifted and the company went bankrupt. This summer we had a more targeted approach. I have to say I don't agree with the designations, as to my knowledge, all those vessels and their owners had taken advice as to whether they were breaching US law or not from US maritime attorneys, and believed that they weren't. and then suddenly found themselves without warning being designated. And that goes very much to the the nonsense actually surrounding the US Maritime Advisory. It's pointless giving all this good guidance as to what you should and shouldn't be doing if the US doesn't bother to investigate whether you've been doing it or not. But leaving that aside, it was only the owning company and the vessel that was designated. It wasn't the management companies in those cases, and I think everybody in the industry was pleasantly surprised by the speed with which the designations were lifted. I do have a question out to some of those owners to say, well, what are the long-term effects? Because the other thing I don't think the US government appreciates is the commercial damage, which I think Leigh was referring to earlier, that is done by association with sanctions breaking. Oil majors won't touch you. They won't go anywhere near you if you've been identified there. And at the moment, understandably, I think industry is reluctant really to be too forthcoming on that. And I'd love to know what the answers to that is. How bad was the commercial damage of that designation, notwithstanding the US things? Probably, I think that they dealt with it pretty quickly in terms of identifying, designating, and then lifting the designations when they got the necessary assurances from the owners concerned. But it is catastrophic. If it's left there, the vessel and the owning company will go out of business. It's a very, very potent weapon.
Thank you, Mike. Can I ask another question, which one of the attendees has put forward? Relating to, in particular, an STS operation. And the question is that the owner may seek from the charterers a certificate of origin of the cargo to be loaded and receives a response to the effect that the origin is not a sanctioned place and no sanctionable activities are involved, but no further details are given. And the question is, will that satisfy the burden of performing adequate due diligence? And if it wouldn't, what can the owner do?
I wonder if I can comment on that a little bit. I think almost one needs to take a step back and look at what contractual language do you have in place and what due diligence processes do you have? Because, for example, in an ideal world, you would have already ascertained that that was the answer you were going to get before committing to lifting the cargo. And I think that's the point that the industry would like to get to, or sort of blue chip players. You want to have that 360-degree picture of what you're dealing with. Now, I appreciate, and we hear this countlessly from clients, that we live in the real world. These fixtures are done in a matter of days and a matter of hours, and so it's very difficult to do that. Which means that you do have to make sure that you have the right contractual protections. That even where so you've got the SES sister ship, and you've done your checks on her, she's come back clean. You've gone and sought advice from the club or external lawyers on whether this trade in principle, if it is what it says on the tin, is lawful. So you've got that. You still need the protections, I think, and we've seen this. Leigh and I have seen this, and I'm sure, and I know Mike will have done as well. That you need to make sure you have language that, as your understanding of the situation evolves, you still have the contractual ability to pull the plug or seek further particulars. And the final thing I would say is that the OFAC and the EU, the UK guidance talks about fraudulent documents. It warns against fraudulent documents. The advice actually isn't very helpful on it, and that's because it's quite difficult to quantify what a fraudulent document looks like. But what I can say is that in all the cases that we've dealt with this year, where you've had duplicitous shipping practices, it's been the documents that have actually been the real smoking gun on it, because whatever it is, a stamp that shouldn't be there, dates on the bill of lading which are just too optimistic for the type of operation that was going on. I mean, it can be anything. But normally, if you put this to the operations team, normally someone can say, "Oh yeah, that doesn't feel right." And so I think when you're looking at compliance policies, the key is to try and make sure the right people are looking at the right things, and that matters are escalated and triaged effectively. And that's what a compliance policy should do. And if you've got that down, if you've got that nailed, then hopefully the situation that's the premise that the question's been put on, you can reduce that. You can reduce the problem there.
Yeah, thank you. Mike, have you had experience of these sort of problems with STS operations?
Yes, I think, and I think Alex is absolutely right to highlight the wording in your contract, because I go back to the point I made slightly earlier, which is that if you're in that position, it's probably too late. The US has no ability to interrogate a Greek ship owner as to the extent to which it has exercised due diligence. So all it will see is a cargo which its intelligence agencies have identified as a sanctions breaking cargo going on to that Greek or Chinese or whatever nationality ship it is. And there will then be consequences. At best, you will be identified, and that will still cause clubs, banks, insurers, flag, class to distance themselves from your ship. At worst, you'll be designated. So trying to avoid that situation is really what's most important. Now, I know BIMCO, and I think my colleague Mark Church, who's well known to Leigh and Alex, are working on currently some STS type clauses. We are really quite nervous about those. We can see that they're fraught with difficulty, and the basic difficulty with these things is that that mere suspicion of unlawfulness is not enough at English law to allow a ship owner to refuse to obey an otherwise lawful order. So if you're ordered to load a cargo from an STS operation in the context of a 5-year period charter party, you're going to need a little bit more than an incomplete AIS record or simply suspicion that something's not quite right if you're going to refuse that order. And so it's really, really difficult. It's difficult because the US doesn't bother to find out what you've done to try and prevent that situation coming up. It's difficult because crossing that contractual threshold whereby you can refuse the order is always going to be a challenge when it's based on pure suspicion. There are no easy answers other than to avoid any trades which you believe may give rise to a high risk. I wouldn't even say an unacceptable risk, but a high risk. If you, as Alex says, if you don't know where the cargo is coming from, if you don't really have confidence in the people you're contracting with, then please try and avoid them.
Yeah, thank you. Mike, I get the impression that the marine insurance industry, and in particular P&I, they have attracted considerable attention from the US and UK authorities. Why do you think that is, and what effect has it had on the industry?
Yes, yeah, it's depressing, really. I think I've scratched my head about this a lot because back in 2010, 2011, when I first got involved in this field, the US didn't know what a P&I club was. And nowadays you'll see a lot of references in OFAC and State Department documents specifically referencing our industry. And I think it comes from the effectiveness of the Iran sanctions program, which they fell into almost by accident. They had no appreciation that so much that essentially everybody needs third-party liability insurance to trade, and they had no idea that so much of that was concentrated in jurisdictions which were essentially aligned to the US. So by targeting accidentally targeting marine insurance and making that one of the things that it was unlawful to provide marine insurance to a vessel that was trading in breach of sanctions back under the old CISADA legislation. They suddenly realized that they struck gold. Now the reality is that independent tanker operators didn't go to Iran carrying sanctions breaking cargo because their oil majors would never fix with them again. But we, for whatever reason, just seem to be that little bit more visible. And the withdrawal of insurance and the publicity that we gave to the consequences of breaking sanctions, I think probably started to attract attention. And then there's been engagement as we've had to explain the consequences of losing third-party liability insurance. After all, it's not the sanctions breaker we compensate, it's the coastal state, it's the fish farmer whose stock has been damaged by a vessel that's driven through it. So it is one of those things. We provide a necessary service to ship owners. We're very visible. We're in a jurisdiction which is easily accessible, and as a result of that, I think there's been an awful lot of reliance placed upon us, probably disproportionate really to the impact the withdrawal of insurance has.
Thank you very much. Well, we're probably at the time when we should wrap up. Is there any other comments which any of you wish to make on these important issues which we've discussed? If not, I'll ask Nick to close the proceedings.
Thank you, Sir Nigel, and thank you for keeping such excellent time throughout the session. That's very good indeed. As we come up to time, it really remains for me, on behalf of Reed Smith and the London Shipping Law Centre, to extend my sincere thanks to everyone who's participated in today's session. We've had a really interesting range of issues covered by the speakers, and a hugely interesting selection of questions and contribution from the virtual floor. So we're really grateful for that. So my thanks to, of course, our chairman, Sir Nigel Teare, for keeping us all on track and keeping us all on time and introducing such helpful contributions. To all our speakers, of course, Mike and Leigh and Alex, and a guest appearance from Alex's cat, whose opinion on sanctions is not yet known, but may yet still reveal itself. And to those in particular behind the scenes at both Reed Smith and the London Shipping Law Centre for making these things happen. They're much more visible in an in-person seminar, but of course they are invisible at these events, but they do so much to keep everything going and to keep the technology running smoothly. So thank you to all of you. And last and certainly not least, to everyone for joining us as attendees today. And thank you so much for your contributions. I will leave it there. Thank you from all of us for joining us, and we all wish you a very good weekend.
Thank you very much.
Bye-bye.
Thank you. Bye-bye.